Landlords update. We got a lot of good information here for you all to take in. I'm joined here by Lon Welsh with Ironton Capital and Your Castle. How you doing, Lon?
Fantastic. How are you?
I am great, and I've got Eric Ross here with CRT Management. How you doing, Eric?
Fantastic. Always happy to be here. Thanks so much.
Awesome, Eric. Excited for you to give us the rundown on all the chaos that is landlord tenant legislation in Denver, Colorado, actually, the whole state.
Most certainly.
So guys, so this is not an offering of investment opportunity. This is just purely an educational webinar to give you a rundown of a lot of the legislative changes from a landlord tenant standpoint. But we have to provide this at the beginning of our presentation as usual. You're not going to really see any forward-looking statements here. Do keep in mind any investment in any fund does involve a high degree of risk. So if after this presentation you want to reach out to us and discuss some passive investment opportunities with Ironton Capital, you are welcome to do so. We'll put our chat or our contact information in here, and just do know that whoever's involved in your overall financial and investment decision-making process, please ensure that they are all involved, as investing does involve risk. And so with that being said, I will turn it over to Lon.
Thank you. I appreciate that. And Eric, so glad that you are with us. This is sponsored by Your Castle Real Estate and Ironton Capital. And we offer a lot of investing products, but we're not here really to talk about that today. If after this you discover that being an active landlord is no longer exciting, call Nick or I, and we'll give you some options that you'll be really excited about. And with that, Eric, the floor is yours.
Well, thank you, I think. So again, very happy to be here. I've been a property manager here in the Denver market, coming up on 18 years. I've gone through a couple of market cycles, and I've definitely watched the legal landscape change in tenant landlord law. We had 9 big laws come out in 23. We had some changes in 24. The supply has obviously grown, and even since these slides were made, we've seen a significant increase both in the sales side as well as the rental side. Excuse me, in overall supply. Demand, flat to slight growth, and I think we're still seeing that. And the headwinds are still there: rents, vacancy, concessions, property taxes are going up, insurance going up. I joke with Lon, this is the best worst pitch for a property manager. So we're going to tell you all the reasons why you shouldn't own real estate and why you shouldn't call me, and you should call Lon. But if I can be of a resource post webinar, I'm always here to help. So let's keep it cruising here. So we're going to recap, and the ones that have been here before, we'll recap kind of some of the stuff that went on in, let's see, there we go, 25. So I guess they moved the slides on us here. So 2025 legislation, we've had a handful of new laws that have passed. HB 1090, transparent pricing required, no hidden or surprise fees. They've prohibited pass-through fees, things like taxes, which I'm not sure what landlords are passing on their tax bill to their tenants, but I guess there was enough of a push to make this happen. Same with some common area maintenance stuff like landscaping, or habitability based stuff like pest control. So on your online advertising, on your application, as well as on your lease, there is going to be a requirement for disclosure. Tenants can sue for violations. They don't have to notify you. The biggest, challenge with this law has been the unintended consequence of RUBS, or ratio utility bill backs. I work with a number of attorneys, including Greg Parham, Springman, Brayton, Wilson, and Pontius, Cheddar, Sulzer. No one can decide how this is going to go. But the biggest thing is you need to be aware as a landlord that flat rate utility bill backs, ratio utility bill backs may be a challenge. No one is agreeing upon the way it is supposed to be done. Cheddar has taken a very conservative approach. My other attorneys say it's a business decision. So should really be mindful on if it's not a metered service. So Excel, water, single family home, you want to be aware that there is some risk involved, and just be aware. What we're doing at CRT is we're making it a business decision by the landlord, the client. We're presenting the risks, and we're going to allow the client to decide, hey, do we want to continue on with RUBS because it doesn't say you can't, or do you want to take the more conservative approach of rolling that into rent with an amendment? So until there's some case law, there's really no good answer. I've had some great conversations with Greg Parham on how we could go about it, but it always comes back down to simply it's a business decision. So just be
Roll the
mindful.
dice and find out.
So that's HB 1090. 1168, more protections for DV victims. The biggest change in this law, there's already been laws
What's
on the
EV again?
domestic violence.
Okay.
So the laws around domestic violence and the ability for a tenant to exit their lease in a DV situation have been on the books. They have expanded this. The biggest change is that prior you would need attestation from either a social worker, police report, organization that works with victims. The change here is they have allowed self-attestation from the tenant that they are a victim. If they tell you that they're a victim of domestic violence, you are required to provide a payment plan in order to get them caught up. Minimum $25 payment for 9 months. That does not include future rent, no late fees on those prepayment or repayment plans. So if your tenant comes to you and says, hey, I'm a victim of domestic violence, my best advice is call your attorney, as you do need to go ahead and provide them a payment plan. You need to make sure that you are protecting their interests. They can end the lease. There are some additional regulations around when they can end the lease, what penalties you can provide. And that's very similar to what's already been on the books. So if your tenant comes to you and again says, hey, I'm a DV victim, you really should reach out to an attorney or someone who's got a little bit more understanding there. 1108, no acceleration or fees on a tenant after death. Not really sure why. Again, we have decided this is necessity. I guess there was one landlord who decided that he was going to charge the estate the remaining 10 months of the tenant's lease, but effective 2025 September, you cannot put accelerated charges, lease break fees if a tenant dies in the unit. You can charge to have your items removed and any actual losses. So again, another law that I don't think was necessary, but they felt it necessary to put it out there.
Eric, quick question for you. So back to 1090, as for those who might be in multifamily on this call, a pitch if you're going to buy a deal is that there's an ability to increase income of the overall asset by doing a RUBS or by doing a fixed chargeback of say 50 to $100 to the tenant that covers things like water, blah, 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 blah. Are you saying under 1090 that presents greater risk and that it might be more difficult to do so if it's not already separately metered for that unit?
That's exactly what I'm saying. So 1190, one reading and interpretation of this legislation states that if it's not metered, you are making up a charge that cannot be verified based on usage. So a great example, you have a duplex. Both are 2-1 per side. You get a water bill, you split it 50-50. The tenant advocate argument is, well, what if tenant A goes on vacation for 2 weeks? They're not using the same amount as tenant B. I think it's a bullshit argument. I think it's a very conservative approach, and I don't believe that the letter of the law or the spirit of the law was for that. It was really to prohibit pass-through fees and make transparent pricing. The
Yeah.
rumor is that the legislature understands that it was poorly written without admitting fault, and they are going to float a bill next legislative session to correct the misinterpretation of RUBS. So if you think about how many large multifamily, 30, 40, 60, 100, 200, 400 door units that have one water meter, how are we supposed to recoup this? And I don't believe, nor do the vast majority of the legal experts that I've spoken with, believe that that was the intent, letter, or spirit. Again, tenant advocates have really grabbed a hold of this. So it's going to be a business decision on how I feel about my risk, which is everything that we do here is risk mitigation. Do we want to go super conservative? Do we want to push the envelope? And as a management company, third party, we are going to push that decision back to the owner.
That's a pretty big can be a huge disruption in the overall value add process, because you see that on like a lot of broker pitch decks, and maybe a lot of the people on this call are more single family oriented, but you see like that on pitch decks where, oh, you can bill back $50 per unit to the tenant because the owner's paying for everything now. But that legislation has made that a lot more difficult and puts you at much greater exposure.
There's definitely some exposure there.
Yeah.
There's been laws on the books for years that does not allow an owner to make a profit on the utility bill backs. And I believe that's where the legislature was going. It has unfortunately created a bit of a cloud around that. So just something to be aware of.
Got it. We got two questions here. So Karen's asking, is 1108 a rent increase for the next tenant?
No problem there. Tenant leaves, dies, and you regain possession, put it back on the market, raising the rent's not a problem there.
Another question, 1090. So I can't charge fees for charge to use credit card to pay water bill on duplex split. Cost 50% for each side.
Correct. So you can't charge that fee because that's not the tenant's fee, and not making profit on it. Again, we believe that the spirit, letter, and intent of that law was to prevent a markup on these type of services. But there's going to be some cloudiness and uncertainty around how this is looked at by the courts and how it's executed across the world. So again, it's really a business decision. Can I still split the water 50%? You can. You run the risk of this being deemed an illegal charge because you can't meter how much is being used by sides. So if it's a single water meter, single unit, and you get the water bill for $125, that's the actual cost. You can bill that back. The uncertainty now comes to, is this a legal charge? Does that make sense?
Yep, absolutely. Basically, the way out is to spend several $1,000s to separately meter your units,
or take your average cost over the last couple of years and add it into your. So if your average water bill is $150, split it $75 a piece and add it into your rent. So instead of rent being $1,150, it's now it goes up. Exactly.
Sure. Got it. Okay. I got another question here. What about chargeback for trash dumpster for a quadplex?
So again, it's in question. I believe, most of my attorneys believe, that that's still okay. That's not what the law intended to do. But the key here that I want to stress enough is, because there is no case law and because the Attorney General has not given us any guidance, you run a risk of it being slightly problematic. Our advice is going to be, make a business decision, and if
probably work in most cases.
Someone balks at it, you probably should eat it. It's tough until we get either some guidance from the AG or they pass another law to clarify this law.
It's amazing the legislature doesn't think through this stuff a little bit before they pass it.
It's hilarious, but it's not funny. So the last law that I apologize, I didn't get a chance to update this slide, is going to be HB 25-1249. And that's HB 25-1249. Nick, if you want to throw that in the chat so someone can look it up. It's going to, so this law is around security deposits, and it's going to update a number of things on the way we deal with the return of security deposit. So most notably, it has defined normal wear and tear. And it requires you as a landlord, if a tenant requests a walkthrough at the end of a lease, you are required to give them a walkthrough, whether in person or virtually. It also restricts specifically charges for carpet and paint. The carpet's older than 10 years, you may not charge anything for it. So it has outlined a 10-year proration of the life of that carpet, and then with paint, a lot of apartment complexes would paint the entire unit when you would leave and charge you for it. No deductions for repainting unless for an entire unit, unless there's substantial damage existing throughout that requires a full paint. Deadlines for returning deposit, it's still the 60 days, statutorily 30, unless it's in your lease for 60. Documentation requirements, the move-out statement or a security deposit disposition is now going to require documentation, so receipts, photographs, etc. So before we just had to give an outline statement that I'm withholding security deposit for paint, carpet, clean, rent. Now you're going to have to provide that proof, and if the tenant requests it, you need to reproduce that documentation within 14 days, even if you've already provided it.
Wow.
Let's see. It's making it more strict on the landlord. The nice thing is that they have officially authorized electronic return of deposits as well as the move-out statement. So if the tenant, you can send that out by ETF or ACH, and send those move-out statements via email. And that allows you to say that you have completed.
Nope. I think we lost Eric. Lon, are you still there?
Yeah, I'm still here.
I think we lost Eric.
Let's just give him a second to reconnect.
Yep. Moved out into the mountains now, and he's
Sorry there. we had a glitch. So it does allow for electronic return of the deposit as well as the documentation. That's that HB 1249. We can pick up on those questions again. Sorry for that slight technical glitch.
Yep. So we got a string of questions here. So for 1090, do we have to change our current arrangement or wait for new tenants?
So again, business decision. There is a path of putting forth an amendment that just tells the tenant, hey, your current situation is rent is $1,200, flat rate utility reimbursement is $75. We're going to roll it all into one, sign this amendment, and we roll it all into rent. And that's if you chose to take the conservative route. If you're billing back for like say 50-50 on the duplex, then you would take your last 12 months of bills, take an average. I suggest multiplying that at 85 to 90% so that you don't exceed it. Give yourself some cushion. And then same thing, hey, we're going to take this water bill. On average, it's been this, and we're going to add that back into your rent. If not, then you can continue forward if you're willing to accept that risk. If they decide that this is an illegal fee, if we get guidance from the AG, or if you end up going to court.
Andrea commented maybe landlords should all just go back to advertising the complete rent. Sounds like
So
that is the case.
that is the most conservative approach. Figure out what your costs are, increase rent. The biggest challenge there that we're going to see is that it's going to create an additional barrier to lease. So if your competition down the street is willing to take the risk, and their rent says 1,200 and then 75 reimbursement, and your rent is 1,275, tenants aren't simply sophisticated enough to understand that they're paying the same damn number. So it really just becomes an optics challenge. But yes, that is the most conservative approach, is to just advertising the complete rent.
Then can you explain the 10-year proration you were referencing earlier?
Certainly. So under 1249, basically the state has said that your life of carpet is 10 years. So let's say new tenants moving in, you spend $2,000 to put new flooring, new carpet in. You can then take that 2,000 divided by 10 years, 200 a year, and that's what you can charge back. So if after 3 years you have to replace that carpet, you can charge, you've got 600 towards the 2,000 that you spent. That is usable life. You can charge back the remainder if it all completely has to be redone. So with paint, if I have a room that needs to be repainted and it's a different color, I can't charge them for the whole unit. I can charge them for the room because they caused damage and or we needed to repaint the room.
Got it. And then when do these bills become effective?
So 1290, 1090, or 1290, let's see, 1249, 1090, January 1st, 1168, I believe, was September, as well as 1108 was September.
Got it. Okay. I know First Bank used HB 25-1090 long before it became law to justify adding monthly fees. I wonder if this also applies to whole life insurance policies. Not sure.
So 1090 has overreaching in multiple industries.
Yeah.
So, I, again, not an attorney. I did not preface that before we started, but HB 1090 is definitely going to have some effects on food service, insurance, etc. You've got to put all of that out there. So it's really that truth in advertising, transparent pricing.
Yep. And then regarding the subject, deposit disposition, what if expenses applicable for deposit withholding are only estimates? In other words, repairs can't be completed in 14 days to have actual invoices.
So not sure why you would have 14 days. Your lease should include a provision that allows you 60 days to return that deposit. Statutorily, it's 30 days. Make sure you have a lease that gives you that 60-day window. And realistically, you should have that work done in 60 days. If it's a really bad turn, you'll want to be extremely conservative. So let's say that, you do have to paint the full unit. You'll want to make sure you undercharge the tenant so it does not exceed those costs.
Okay. And then can a landlord refuse to accept housing vouchers?
Oh, goodness. So short answer, no. Source of income is a protected class. So if they receive a voucher, that is a source of income. The reason that you can deny a voucher is that the voucher does not cover rent, less utility allowances. So if your rent is higher than the voucher, absolutely fine. But if the voucher meets or exceeds your rent, you can definitely put yourself in some liability refusing to accept the voucher.
Got it. I'm going to skip this one question and go back to it. But back to the security deposit, you mentioned something about 14 days. What was 14 days?
Not sure what 14 days are. And let me pop back over to make sure I didn't miss anything. Documentation requirements. So if you send out your move out statement, security deposit disposition, including your photographs, inspection reports, receipts, invoices, if the deduction is for unpaid rent, the landlord must include the tenant ledger. Upon request, landlords must reproduce that same documentation within 14 days, even if you've already provided it. So that's the 14 days.
Got it. What if the tenant has agreed to pay taxes on a residential triple net lease? What about pet fees or pet rent? Does this affect commercial leases, Eric? 1090?
It does not, but that's a residential triple net lease. That seems problematic. I definitely seek legal advice there. But based on HB 1090's reading, that would be probably unallowable. Pet fees or pet rent. Pet fees have become a no-go. So you can do a a refundable pet deposit, 300 per unit, and you can do 35 a month in pet rent. We take the conservative approach of by unit, not by pet. Non-refundable pet fees are a thing of the past.
And then, is there any discussion on the state level or professional level as to how requirement to accept vouchers could become huge risk if some of the possible changes or restrictions come down after the cuts in the BBB? Possibly, for example, possibly 2 years max for Section 8, for example, has been thrown around.
I wish I was that smart. So we're dealing with this on a day-to-day basis. Is there any discussion? You can look at what the state's done in their current budgeting, dealing with the BBB and the shortfalls that occurred to state revenue. How the state decides to deal with that on the housing level, I really can't. I can't speak to that.
And then on the pet fee and pet deposit topic again, how can you identify that the ESA certificate is legit and not bought from Amazon?
Great question. So this gets really into the nuance of fair housing, FHA. What's very clear is an ESA certificate means nothing to us. So for an ESA, what I can ask for is a letter from a healthcare provider identifying that the applicant or the tenant is under the care of that healthcare provider, that the presence of an ESA is beneficial, and they're asking for a reasonable accommodation. So that's what we ask for. If it's a service animal, it's a completely different ball game, and service animals are dogs, and they are trained to perform a specific task. You cannot ask what their disability is, but you can ask, has the dog been certified? Has it been trained to perform a specific task? If they can answer those questions, leave it alone. Service animals are really tough. ESA, we can ask for that letter from the healthcare provider, and that's what we utilize as our documentation.
And what about pet damages and withholding security deposits?
So again, if you have good documentation of move in, good documentation of move out, those are damages beyond normal wear and tear. Irrespective if it was caused by the tenant, the dog, or their kid, you can absolutely charge back for damages beyond normal wear and tear. And if there is a pet deposit, you do not have to link it necessarily to the pet. It's security deposit.
Is there a limit to the number of pets someone can have?
No, it's landlord by landlord. So you as a landlord can say, I limit it by 2, keeping in mind that an ESA or a service animal is not a pet. And if they have a letter for their 17 cats and they have a letter for each of them, there's gray area, right? So, but if you as a private landlord says, I allow pets, but I limit it to 1 pet, not ESA or service animal, that's perfectly fine.
Can I limit it to 0 pets if not an ESA or service animal?
Absolutely, you can. More than fine. Just keep in mind that it does create a barrier. Somewhere between 60 and 65% of all Colorado renters have pets. Colorado loves their dogs, so you do lower or shrink the applicant pool if you say no pets. But it is perfectly, you're right. If it's an ESA or service animal, you cannot deny that.
And then can you take a non-refundable deposit on a rental?
No. It's a deposit. It is refundable under multiple Colorado laws.
Well, that's all the questions so far. Really good questions,
Great.
guys. So
We'll
Good questions.
keep cruising. So we'll go backwards in time. 2023, we'll kind of cover these quickly as they've been in place for some time. Pet ownership and housing. So that answers some of the questions about pets. It does say, excuse me, $35 a month pet rent, $300 refundable deposit. The law that passed in 2025, I believe, around pets also limits insurance companies from breed restrictions. So something to keep in mind. HB 1099, Portable Screening Acts, Portable Tenant Screening Acts. This was supposed to be the end all be all. It's been a non-issue. So if a tenant brings you a Portable Screening Act or a Portable Tenant Screening Act certified or applicable screening report, you should take it. It doesn't preclude you from running your own background check. It just precludes you from charging the tenant. So I'm sorry.
How often do you actually see that happen?
1 in 10, 1 in 12, they'll give me something and we go, great, thank you very much. We put it in the file. We still run our own, and then we credit them the application fee. So it's really a non-issue. Prohibited provisions in rental agreements disallows several clauses, mostly around class action lawsuits and removing landlord protections or exculpatory language. So that has been a relative non-issue. 1120 eviction protections slows and complicates the legal eviction process. I believe 1120, and I'm not as up on these as I once was. I believe that created the mandatory mediation for tenants with subsidies. And it, so if a tenant receives SSI, so Social Security, supplemental income, disability income, or TANF, they're entitled to mediation. You go through mediation, it's non-binding. If nothing comes out of it, then you still move forward with your court case. 1186 allows remote participation in evictions. So circa COVID, it allows you to show up in court via video chat as we are here today. Habitability of residential residents. This mattered in 23, but doesn't matter because they rewrote and bastardized the law in 24. So we'll skip over that. Illegal drug labs. So it does increase the requirements that if, just like we had meth labs in for sale homes, we had to remediate. It brings that over to the rental side and disclosure. Protections for residential tenants on SB 184. This was a big one because it did prohibit the use of credit or negative credit information for subsidized individuals. That was a big one. So if a tenant receives Section 8 benefits, house choosing voucher, it does preclude you from using a credit score or negative information for denying the housing. And the overreaching side of this is it has limited the landlord's ability to deny housing based on these myriad of laws. So before, you could just be like, I don't have a good feel. Now they've put these additional protections in, and it requires you to have a reason to deny housing. And it's just created an additional barrier for us landlords, both professionally as well as private landlords, of denying folks housing that we know aren't suitable for the housing. And this is a big push to deal with the homeless issue, housing now, and a housing first model. Excuse me. Finally,
Eric, we got a bunch
ahead.
of other questions. Do you want to? I don't want to disrupt your flow, but do you want to address them now or wait until you?
Let me
do
just hit this
slide?
radon, and then I'm happy to go through those. Final item: you have to disclose radon. So this is both on the sales and the residential side. If you've tested, you have to disclose the tests. If you if you have tested and it's above the EPA level, you have 180 days to remediate. If you don't disclose, it makes your lease voidable. So that's the biggest thing there is if you haven't tested, just like lead-based paint, we have no reports or records to. Therefore, you have nothing to disclose. Nothing needs to be done. If the tenant requests a test, they may have it tested at their cost. If it's above the EPA levels, you have 180 days to remediate. So happy to happy to answer questions here.
Karen's asking, how about a non-refundable application fee? Is that permitted?
Absolutely. Application fees can be non-refundable. Once we run your credit or background, that's not refundable, irrespective of if you take the unit or not. Yes.
Got it. And then, do you know anything about refundable deposits in Florida?
Nothing. There be dragons.
I would guess that they're probably a little bit more relaxed than they are here, but that's
But
just
haven't the slightest clue about Florida. I apologize.
Is pet rent for a emotional support animal or service animal allowed?
They are not, because they are not considered pets. So once they become an ESA or a service animal, they are no longer pets, and any fees or deposits are not allowed.
What's the limit on application fees if there is one?
So I believe it was 2018 or 19, and we could probably go find it, but it says that you can't charge more than the cost of you running the background report plus an administrative fee. I charge $55. My background checker charges me $48, and I charge a $7 administrative fee to enter the information and run it. We've had no issues there, but there's not a limit so long as it's actual cost and a reasonable administrative fee.
Okay. If a housing voucher does not cover rent, can you then consider credit score?
Well, if a voucher doesn't cover rent, then you would not be renting to that voucher holder. So I would imagine you could. Keep in mind that if it's a federal subsidy, Section 8 housing choice voucher, then you are bound by the HAP contract, which prevents the landlord from taking any additional funds outside of the lease or the HAP contract. So not sure what the intent there is, but let's say a tenant's rent is the rent is $2,000, their voucher covers $2,000, and their portion is any portion of it 0 to 30% of their income, you would not be considering credit there. I hope that answers that. It's a little vague. Sorry.
Let's see, SB 23-184 does not require radon testing, correct?
It does not require you to test. It does require disclosure if you have tested.
Okay. And then on SB 23-184, can you deny on previous evictions?
184 protections. So yes, so long as it's disclosed. So private landlords and third party are a little bit different. I have a minimum published criteria, and it says that if you had eviction in the last 3 years, we can deny you housing. So we disclose it up front. So best practice, even if you're a private landlord, on your Zillow ad, put what you're looking for. 650 credit score, 2 times rent gross income, which is state law, no evictions in 5 years, and whatever your criminal requirements would be. Disclose up front. If you decide on the back end that oh, you had an eviction 7 years ago, I'm not going to rent to you. You expose yourself like anything else to liability.
Also on 184, can we deny Section 8 prospects due to previous evictions, owing previous landlords money, or if the previous landlord does not give a positive report? In general, besides credit, what else can't be used as a decision?
Great question. Previous evictions, again, because we're third party, if there's an eviction, we can deny housing on that. Owing a previous landlord money, if that is part of your criteria, it's disclosed. I think that's probably okay. If the previous landlord did not give a positive report, that's super subjective, right? So I'd be very, very wary of denying, especially a voucher holder, on a previous landlord's less than stellar landlord reference. It could be an interpersonal challenge. It could have been a number of things. So I would be very wary if it's not very objective. If then else, I would be wary of doing so.
Okay. And then on the rent, the 2x income to rent ratio, that's gross, right?
Gross.
Not net. Yep.
Correct.
That's pretty amazing because gross, I mean, you can easily arrive at a net that is barely above your rent. So like, how do you make room for any other expenses in your life?
Oh, the legislature has 100% okayed a 50% housing debt to income. Yeah, it's absurd.
Unrealistic.
And it again is part of the housing first model that we're pushing. But you know, the rule of thumb everyone has been in real estate is
3x.
a third, right? You should spend no more than a third on your housing, and that's been the standard until they lowered this to 2x.
So because of Section 8, you can't put a minimum credit score on the listing.
You can.
Okay.
You absolutely can. So 123 Main Street is available for rent for $2,000. Minimum requirements 2 times rent, 700 credit score. But if a tenant comes along, they have a voucher, and they apply, then you can't use that credit score to deny for the voucher holder. You can for a non-voucher holder. It sounds like fair housing to me.
Got it. That's everything.
Great.
To this point.
All right, let's keep it cruising here. We're not done yet. HB 1098. So this has been one of the most interesting and I think operationally challenging things that came into law April of 2024. So previously, as a landlord, if a tenant wasn't a good fit, we just simply wouldn't offer a renewal. We had no reason we didn't have to give them a reason for non-renewal. We just simply had to state that we're not renewing your lease. Here's your notice to vacate. Have a good day. This law has changed that, and it states specifically that if a tenant has been in a residential listing or residential unit for 12 months or more, and this is key, then the circumstances that you can deny a renewal are listed here. Non-payment of rent, pretty straightforward. If they don't pay the rent, you can absolutely evict. Material violation of the lease, repeat violations after receipt of proper notice, substantial violations, and let's be very clear what substantial is: drugs and violence. If it's not drugs and violence, it's likely not substantial. Creates a nuisance or disturbance that interferes with other quiet enjoyment, and when they're negligently damaging the property. So this is there's huge punitive damages around improper use of this. The key to this, and I think it's on the next slide, I'm going to peek. Here we go. Non-renewal notices or notices to vacate. These are the reasons that we can give them. So what was here is this is for cause. If they do any of this, we can still give them a notice and we can still evict them for cause. Not no fault evictions or not for cause are notices of termination for these reasons: planned substantial repairs or renovations to the premises, It gets pretty detailed in here. So back in the day, we could just say, hey, we're updating carpet and flooring throughout, tenants got to move. That's not going to cut it anymore. It's got to be substantial. If it's going to exceed, I believe it's 90 days, but less than 180, you have to give a tenant the right of first refusal. Planned occupancy by the landlord or the landlord's family member. Again, there's some nuance here. If the landlord owns multiple units, there has to be no other unit available. Planned withdrawal of the premises for the purpose of sale. There's some gray area here. It says that if you remove it for sale, that it has to be off the rental market for 90 days, unless it's listed on a multiple listing service, MLS. And then there's no date or time. It needs to be reasonable. So you can't list it on the MLS for 1 day and then take it off and then re-rent it. That's abuse of this statute. The biggest one that we see is the refusal of a tenant to sign a new lease with reasonable terms. So we give them advance notice of the terms changing. They refuse to sign it. You can give them a notice to terminate under that. And then here's where you've got to put the dumbest hat on. A history of tenants' late payment, more than 10 days, more than 2 times, and not cured under the current statutes. So meaning it's 10 days late, you've given them a notice to pay or quit, and they pay outside of that demand period. And it has to happen more than 2 times, so just say 3. All of these no-fault provisions require 90-day notice before the lease ends in order to give them that notice of termination.
So do all these apply if you just do an 11-month lease instead of a 12-month lease?
So, they've gone to such extremes to create this. So our response to this was all initial term leases are 11 months. And so if you're a bad actor, a bad fit, it doesn't work. We just give you a 30-day notice to terminate, have a good day and move on. But once they hit that 12-month mark, this statute does apply.
Gotcha. Okay. Let me ask you this too. So what if you're on an 11-month lease, but you pivot to a month? Now you're in there for 12 months. Are those essentially 2 separate leases, or is that now do all these laws take effect?
These laws take effect. And so once you've hit that 12-month mark, the tenant has a month-to-month lease and can give you 30-day notice, likely due to your lease. The landlord is on the hook for a 90-day notice, irrespective of the month-to-month statute or the month-to-month language in your lease.
So let's say hypothetically, ultimately the leases have to reflect all these changes, right? So let's say you sign an 11-month lease. In the lease, it states that, it'll pivot to a month-to-month if you wish to do so. How does that work when you've got this 11-month lease that maybe doesn't state all these items, or maybe it does? How does that transition work?
So best practice, right, is you're out in front of it, right? So we as a management company, we're dealing with our lease terminations at about 155 days prior to lease expiration. So we're talking to the landlord, do we want to re-rent? We're doing an inspection to make sure the tenant's eligible for renewal. We're sending that lease renewal out if we've so desired at that 120-day mark. They have 30 days. If they don't sign it and we get to that 90-day notice, we're giving them that notice to terminate. We can always rescind the notice, right? So it's really being out in front of it. But if your lease goes month to month, that's fine. But it's only month to month for the tenant once you exceed that 12-month mark.
Got it. Comment here. Actually, really good question here. So Audrey spoke to a legislator about some of the new landlord laws causing problems for landlord and causing more landlords in Colorado to sell their properties instead of continuing to rent out the homes. What are the most problematic laws on the books right now for landlords besides 50% rent to income or half gross pay?
HB 1098 is a challenge. It really is. 184, not allowing me to look at credit score to see if they're a qualified individual. 1120 protections against residential tenants, slowing down that legal process. If we go back to HB 1090, the unintended consequences of doing away with billbacks for larger multifamilies, the security deposit law 1249, and you can go back to 22, 21, 2019. There has been a degradation of landlord rights and our ability to contract that has been targeted over the last 4 to 5 years, as there's been a supermajority in the Colorado State House. I'm not here to lean left or right. Look at who's been there. Look at who's done this, and that's what we've seen. So there are a number of challenges that go beyond the 2023 through 2025 laws.
With a domestic, with a DV case, non-payment of rent doesn't apply because we have to give them a payment plan. Are there any parameters of the payment plan if one of the tenants comes off the lease and a new lease is done with one tenant? Does that continue to count their time or start the time over when I can do an 11-month lease?
So from the time a tenant moves in perpetuity is your clock. There's no starting it over. So once a tenant has resided 12 months in that property, HB 1098 applies. There's no resetting unless they move to a different unit. So there's really no way to reset that clock with that tenant in there. The non-payment of rent, because we give them a payment plan. So let's say that they say that they're a victim of domestic violence, sexual stalking, or sexual violence or stalking. That allows them, let's say there's $500 a month or $500 unpaid. You create a payment plan over 9 months, minimum $25. That stops the clock on previously owed. They still owe future rent. Tenant comes off, you sign a new lease, they're still in there for 12 months. Does that all make sense?
So we got 7 minutes. Eric, do you have a couple more slides you want to run through just real quickly, and then we can address all the questions?
Yeah, so HB 1098, the final pieces here, it must, if you're putting a demand, it must state the lease violations. It must be in English, Spanish, or the tenant's primary language if it's known to the landlord. And it requires 2 attempts to serve. If not personally served on the first attempt, then you can post it on the door as we had done in the past. Warranty of habitability, this gets super deep in the weeds. If a tenant calls and says, hey, I'm saying warranty of habitability, call your attorney. There's a lot of stuff going on here. There's a lot of nuance, and it does present some challenges. And then, my fun stuff, but don't, that's not important. Let's talk about questions.
All right, let's see here. I'm trying to find where I left off. So does a 12-month statute of notice of non-renewal apply if it is at month 9 of an initial 12-month lease?
Does the 12-month statute of so if the tenant's lease term or the time they are going to be in the unit hits that 12-month mark, then yes. So again, if we're going to give a notice, I have a tenant right now that they've been late already 4 times in the 6 months they've been there. We are going to provide them a notice of non-renewal pursuant to HB 1098 late payments. And we are going to provide that 93 days prior to that lease expiring.
All right. Let's see. Can I evict a tenant who has subsidized rent when tenant has changed the lock without prior written authorization, as stated in the lease, even though tenant later provided keys to the new lock?
So that's a notice for compliance. If it states that the tenant can't change the lock, you give a notice for compliance. They comply, it ends. If they were to do it again, you may be able to have a case, a notice to quit for repeated violations. If there's a good reason that they're changing the locks, they, just be careful. Can you we live in a litigious society. You can sue anybody for anything, right? But just be mindful that, especially if it's a subsidized tenant, they're going to have some additional assistance in that, and tenant advocates. So if they change the lock, you give a notice for compliance, they provide a key, they've complied.
Are there any advantages to, I apologize, LI? I'm not really sure what that is.
Not sure.
Like
Melinda, if
lease
you could,
insurance or
Melinda, if you want to throw that back up there, we can come back to it.
yeah. Let's see. Are there any advantages to be a landlord who lives in the house and I'm renting out my basement?
There are some additional protections if you're living in the home. It gets really, really nuanced. Their older laws have some carve outs for it. Newer laws have less carve outs for it. Please call an attorney.
What are your typical management fees?
Well, post NAR settlement, everything is negotiable, even my fees. But typically, you're going to see management fees somewhere around 8 to 10%.
Got it. HB 241318 states now that tenant with supposed disability can request modifications that landlord has to pay for, and then when tenant leaves, tenant does not have to restore to original condition. I didn't hear this one mentioned, but can you shed any light on it?
I don't know that one, as it's not been something that we've had to deal with. Again, I'm not an attorney. I'm looking it up here really quick. But I believe it goes around modify rental premises with a person with a disability. It is going to pass into law May of 24. It does shift provisions around a reasonable modification. It does present some no restoration requirements. I don't have this popping up a lot in my world. That's why it's not been a challenge. But it sounds like the modifications must be reasonable for a tenant to enjoy their life. So it's likely the case. Unfortunately, I don't have a ton of information on that. I apologize, Karen.
no problem.
Then domestic violence cases can change locks.
That is correct. So if there were two tenants in the property, and there was a domestic dispute, before we would be quasi limited in our ability to change the locks if a tenant was removed or left. Now this law specifically allows us to change the locks to protect the DV victim, which is one of the few advantages of that law.
Can you get any documentation of the disability or a letter from a doctor that it's necessary?
I don't think so.
You've got to be really careful around medical information and asking about disability. You know, if it's a really large scale modification, consult an attorney. They're going to give you better guidance than I, Nick, or Lon can.
All right, one more snuck in here. Can one tenant remove other tenants' personal belongings in a domestic violence case that hasn't gone to court yet?
I don't know.
That's not my problem. We as a landlord, I'm not going to remove their belongings, but if their roommate or significant other threw it out the window,
Sounds like their problem.
it's not my problem.
Yep.
Wow. That's a lot of great questions.
Yeah, absolutely. Well, guys, if you have any other questions, there is Eric's contact information. Obviously, a wealth of knowledge. Jim asked how you remember all this stuff. That's a very good question.
Oh, Jim's a client. We talk about this all the time. Thanks, Jim. I really appreciate it. For all my clients that are on the webinar, thanks for being here. You know, we get great information from Lon and Ironton and your castle. So just happy to be a resource. and continue doing that.